Hey folks, Corey Kupfer here. Listen, I want to talk about something. This is directed towards any kind of company that is either starting up or doing new branding, and also to the marketing firms out there that are helping them. As an attorney, I've just seen this happen over and over and over again. It's just happened, most recently, and I just want to make sure that folks understand a few things about this. Over and over again, what I see happening is branding companies help people either establish their brand or rebrand, and they work on logos, they work on maybe new naming, new branding, all that kind of stuff, whether it's for a company or a product. And very often when I get involved as an attorney, I'll say to them, well, did you do a trademark search? And the client will say to me, my marketing company says they did a search. Now, almost inevitably, the marketing company has done what we call a knockout search. And that knockout search is a search of the USPTO.gov database. Anybody can go on, it's all online nowadays, to see who has a federally registered trademark, and you go to USPTO.gov and you do what's called a basic or a more sophisticated trademark search to see if there's a conflict. The problem is that, first of all, many of these marketing companies only search the exact naming or branding that they're using, whereas there could be variations that other people have that could conflict on a trademark basis with what they're doing, and they don't understand that fully. That's number one. Number two, the USPTO.gov search is not a comprehensive search. The way it works in the US, unlike in Europe, for example, in the European Union and other countries, is we're not a first to file country for trademarks, meaning that just because you're the first to file for that mark, for that name, for that brand, doesn't mean you have the rights. We're a first use system, meaning that if somebody's been using that branding in interstate commerce before you, even if they don't have a federally registered trademark, they can have rights over you, okay? And listen, this is not specific legal advice for you, it's a general overview. I'm just trying to give a warning here. So for our clients that really care about their branding, which is most companies these days, we're always going to do a comprehensive trademark search after we've done the knockout search at the USPTO level, even after we've done a Google search. There are search companies that do comprehensive searches that search everything from online phone books to Dun & Bradstreet reports to, you name it. It's just way, way more comprehensive. And the reason we do that is because I can't tell you how many times. Now listen, don't get me wrong. It's a minority of the time. It might be less than 5% of the time, a few percent, 2-3% of the time, where a branding company says, oh, everything's good because they've done the search, the basic search, and somebody ends up with a problem. So, the odds are you're going to be okay, especially if you've done your own Google search. But even if it's a few percent chance, the problem is when somebody comes to you and says, cease and desist, you're violating my trademark, because the search that's been done by you and or your branding company is not comprehensive enough. The downside of that is significant. You got to pay for all new branding. You got to change your website, your brochures, your business cards, any printed material you have, if you have any these days. But certainly digitally, you got to go back out to the market. Any goodwill you've established with that brand, is no longer useful, because now you got to change the name. You got to go back to clients. You got to refile with the state to do a name change. So the downside is significant, and in concept, you could even be sued for breach of trademark and be liable for damages. It's very rare that happens. Usually, if you comply with a cease and desist letter, that won't happen, but it could happen. So I'm urging anybody who is doing new branding or starting a new company or whatever it is, not just to rely upon when their marketing company says we did a search. You want to find out what kind of search they did. And most times, because they're not lawyers, I'm not blaming them. Although the thing I would encourage you branding folks to do is to make clear, at least understand enough about trademarks to tell the client, hey, we've done a basic search, we've done a knockout search, we've done a USPTO search, but you should speak to a trademark attorney and get advice before actually, and this is maybe the reason why some branding companies don't do it, because it slows the process a little bit. Ideally, you want to do that search before you pay a branding company to go forward with the branding, because if it turns out it's a trademark issue, they're going to have to redo it, okay? So I'm not looking to demonize anybody, right? We all have our own expertises. In fact, frankly, I mean, trademark is not the main thing that I do. It's just that we do have trademark capacity in my firm. Many of you dealt with Only Hers, and it's just part of what we end up doing for clients because we set up a lot of new companies and work with companies that are growing in branding and that kind of stuff, ancillary to all of our corporate and deal work that we do. And this just comes up way too often, and you can avoid it by doing things right, by doing full searches up front. And I hate to see it. I mean, we've had situations like we just had one recently where we found a conflict, right? And now it's before the client launched, so they're not in a situation where they got a cease and desist letter, but they are in a situation where they've already worked with the branding company, come up with branding, and they're probably now going to need to change it. Unfortunately, we caught it before they went live. So just a little public service announcement. It just happens, too often. So speak to your attorney about trademark work. Don't just rely upon the search of the branding company. And branding companies, please explain that distinction to folks, right? It's not your job to do comprehensive trademark searches, but I think it would be a service to your clientele to let them know they should do that, or at least consider doing that, because there is a risk that your more limited search will not protect them fully. And the last thing you want as a branding company is to have done all this work for somebody, they go and they launch, and then it turns out that they get the cease and desist letter later. The client's not going to be happy with you either. So it makes sense for everybody to do it. All right, folks, just some thoughts, trying to save you some trouble. Talk to you soon. Corey Cuthbert.